Welcome to my page, Law Uncut. This is Dr. Nkirukata Sewachukwu, and this is a continuation of the series Tenants Know Thy Rights. I once had a landlord who was always audacious to approach me in May for a yearly tenancy that had already been paid in January on the guise that he needed a chieftaincy title. So I felt if he was audacious enough to do such a thing, then he ought to be generous enough to remove a certain percentage from the money. So we drew up an agreement whereby if anytime he approached me in May, respect, even though I had already paid in January, then he ought to remove a certain percentage from subsequent rent that was going to come. That's the next rent. So should you find yourself in such situation, you must insist that your interests also be protected, because in actual fact you're doing him a favor, and this can only work in the event that you have a tenancy agreement. Now when you move into a house, the natural thing is that the house ought to be under tenantable condition, and then you move in and you notice that there are certain things about the house showing that the house is not in tenantable condition, and for some reason you're still desperate to move in. You can sit down with your landlord and have an agreement, and the agreement to say that you will take care of those repairs that have arisen in event that the rent that will come, that's the subsequent rent that will come, the amount of the repairs that you made will be deducted from those rents. But make sure that there is a written agreement to that effect, because I've had situations whereby friends of mine said that they actually approached the landlord subsequently to effect those promises, and the landlord rescinded on his previous agreement because there was not a written agreement to that effect. So do not make that mistake of allowing yourself to be caught up with the oral words that your landlord has already uttered, so that you'll be disadvantaged.